Good morning.
Good morning. Please the court. I'm Ruth Greenberg on behalf of Mr. Nathan Ruell. And I inundated the court with paper on this one, I know. And but when you go back and look at it again, what I'd like you to look at is the reply brief first, which is all 5-6 pages. And the reason I want you to look at that part first is because I want to speak very briefly about the question of actual innocence and how it relates to the law in this case. And what I want you to do is first look at the Commonwealth's footnote, which says this is a crime committed by a gloved intruder. And that seems to be very clear. The Commonwealth says so too. There's no fingerprints. There's nothing inside the house where this terrible murder was committed. And the murder, it's clear, like the Commonwealth says, is committed by someone standing on a chair, basically pushing up a screen and then pushing up a window. And then
But you've got DNA evidence, don't you?
Now, see, that's the thing. You always say, well, we got DNA, it's open and shut. But you got to think of open and shut. You got to think, where is the only place where you have DNA? So what you...
Window. It's in the window in a cigarette.
But it's not, the person opening the window is gloved. The person opening the screen is gloved. There's no prints, there's no DNA.
We agree that the cigarette was stuck in the window to keep it open?
Yes, and that's the thing. If you put on your gloves to open your window and open your screen, and then you have your gloves inside, it just seems so unlikely that you would then, standing on a chair, having opened your window with your gloves hands, whip off your gloves, take out your cigarette, put it in the window, put your gloves back on. It's not...
Why do you, I'm sorry, but I'm
And
missing
why
why
am I
you
bringing-
assume that you take the gloves off to take the cigarette out of your mouth and put it in the
It's
window.
not it's handler DNA. It's hand DNA. That's why. So, that's the question. And you could say,
Well, let's flip it over. Then
Yeah.
is it more likely
Yes.
that whoever did it looked around and found a cigarette on the ground or someplace else and just said, I'll take this with me and I'll use it when I open up that screen? That seems improbable, doesn't it?
well, and here's where it's a wonderful thing to have a bench from a variety of life. You know, cigarettes are $8 a pack. So a lot of people say to each other, can I have a cigarette for later? A lot of people take a cigarette out of a pack when asked or when they have friends and give 2 cigarettes to someone else for later. Because, I mean, not in Marblehead, but certainly people who are working for a living, do. So, and you might say, well, so what? I'm not here to make closing argument. I'm not here, you don't sit as a second jury. I know that. But you do sit on what's a miscarriage of justice, and you do need to consider what might tip a trembling balance with a jury when the jury is looking like for a narrative. Is there an explanation here consistent with innocence, and do we believe that more than the explanation that's consistent with guilt? Because it's not really that DNA on that cigarette. That's not. It doesn't make it an open and shut case for this person's guilt.
Even if we follow your logic, so maybe someone gave a cigarette to someone else. That means the person who had the cigarettes put their hands on the cigarette.
Right. But you don't always leave handler DNA. You only sometimes do. So here's the thing. So then we say, okay, then who is it? And that's when the defense puts on third-party culprit evidence. And third-party culprit evidence, we have a long tradition. You're allowed to put it on. The United States Supreme Court addresses third-party culprit evidence in Holmes versus South Carolina. And it says we respect the traditions of the states, and states are allowed to have third-party culprit evidence rules, and we do, but they have to not infringe on a weighty interest of the accused, and they have to, well, you have it in my brief. And we have a third-party culprit evidence rule in our state, and it's Commonwealth versus Finney, at least here, and the judge looked at Finney and said, the judge read from Finney, so we know what standard he used. He read from Finney when he made the decision, and he says, well, if it's substantially more probative and does not confuse the jury, then it comes in. And then he rules everything out.
And assuming for argument that the use of the substantially is incorrect,
Yes.
why doesn't, what about this third-party culprit evidence meets a lesser standard? I mean, do we even need, I mean, the cigarette, the Camel cigarette, we only have one that's got DNA on it, right?
Mm-hmm. Right.
So the fact that somebody has a Camel cigarette, and it's the defendant's DNA, so somebody else has a Camel cigarette and is near, I'm just wondering, does your purported third-party evidence meet a standard that you would find acceptable, the Holmes standard as you
The Holmes
determine?
standard. Well, it's an interesting question. I mean, the first thing is that we don't know what a trial judge would have thought had he been using a standard which was constitutionally correct. So what a defendant is allowed to do is to have a trial judge using the correct standard. He's allowed that first shot at it with a trial judge who considers it right there at the trial. So that's a shot he didn't get. So not only, I mean, you don't sit as a second jury, but you don't sit as a second trial judge either. It's the trial judge evaluating using an incorrect standard. We don't really start all over again. We have a decision to which we need give no deference if it's true that he's applied the incorrect standard. And then we have an offer of proof where you could get 5 different opinions, 4 different, 6 different this week.
But specifically, I mean, I've looked at your brief, which is a little bit weak in terms of precisely what the offer of proof is. What is your strongest offer of proof as to any of these third-party culprits that you say we should find to be error for not having, for the judge not having admitted?
Okay. Well, for one thing, it's error for the judge not to admit a group of them, because it isn't, as the Commonwealth says, that the DA would then be obliged to disprove every single third-party culprit.
I'm looking precisely for, I'm looking a little
You
more
wanna know
concretely.
who-
I
you
want
wanna
to know
know who did
precisely
it.
what evidence you say the judge should have admitted, which the judge did not, as to
Okay.
your strongest third-party culprit.
Chartier. He walks around with a hatchet. He smokes Camel Wides. He hangs out in that place by the hospital in the parking lot across the street, smoking, hanging, carrying a hatchet. He's got warrants out. He's got a financial motive. He's got opportunity. We know that everybody, till we come up with Mr. Ruell, the police drive all the way to Georgia or fly all the way to Georgia, and they give him Miranda warnings. He's that much of a suspect. So he's a suspect.
Okay, and was he the one who they checked the DNA and it did not match the
Doesn't
cigarette?
match the cigarette.
So they have an affirmative, so plainly his DNA is not on that cigarette.
But that doesn't mean it wasn't him. And that's where you're looking at the Holmes rule and you're looking at what's the nature of handler DNA. All it means is they're hanging in the parking lot and somebody gives it, and he has a cigarette which was at one time touched by Nathan Ruell. Because the person who has a cigarette, it's like a library book in some circles, and that's where I always come back to the breadth and the breadth.
But you know that in Holmes,
Yes.
the third-party culprit had told other people that he had committed the crime.
That's correct.
I mean,
But-
Holmes is a much, much more compelling set of evidence than what you have here.
Right. Holmes is more compelling the evidence, but that's not what we're arguing about. We're arguing about, can you have a third-party evidence rule which says if the Commonwealth's case is overwhelming in one way or another, does that mean the defendant can't put on a case? And the answer is the defendant under Holmes is entitled to put on a case no matter how compelling the Commonwealth's case is, because otherwise you would have a judge saying their evidence is really good, you don't get a trial.
Okay, but I
and
guess
that's not what we have.
What I find a little bit, I mean, our case law is very generous to defendants with regard to third-party culprits. I mean, if the evidence is of substantial probative value and will not tend to prejudice or confuse, all doubt should be resolved in favor of admissibility. That's
Okay.
Commonwealth versus Conkey.
Conkey and in Silva Santiago, which is yours.
Right. Well,
So-
I quoted Commonwealth versus Conkey, but
Conkey and Finney, but
right, but I mean,
substantial probative value is not generous toward the defendant. Substantial probative value is way more heavy on the defendant
Okay, so
than
what-
the admissibility for any other evidence in the Commonwealth. Substantial probative value and not tend to confuse is a big push. It's way worse than than prejudicial than probative.
and the standard you would put in its place is what?
The same one that applies to all the evidence offered by the Commonwealth, which is if it tips a trembling balance in favor of the accused, if it's even the slightest bit more probative than prejudicial, then it comes in, because that's the standard that we use for everything else.
Okay, but in Silva Santiago, which I'm sure you've read, you note that we discussed the concern that any time a third-party culprit is mentioned, it does shift the evidence to have the Commonwealth essentially address why it's not him, and you have a diversion of the jury's focus into why the court, you're saying, should employ no judgment in terms of whether that diversion of focus is appropriate?
Well, you know what? The jury is always confused. It's not any more complex than, say, when the Commonwealth offers prior bad acts, which the Commonwealth always does, and then the jury has to sift through 19 stories of Commonwealth bad acts. And also, the Commonwealth has the burden of proof. That's the system. And also, the Commonwealth doesn't actually have to disprove each one of these guys, because that's not what it's about. All the defendant shows, when the defendant shows, as here, 5 alternate suspects, what the defense does, the narrative of the defense, as it were, is to say the Commonwealth has no more on my guy than 5 guys in the parking lot, except for a shared cigarette.
And admissions made to 3 other individuals who
Okay.
testified at trial.
And
Right,
shared
and-
is your gloss. I mean, there's no evidence that this was a shared cigarette. Is there?
No, but there's no evidence that it isn't. There's no evidence that it's not like a library book, a cigarette handed from hand to hand, because nobody put it in their mouth. It's a hand to hand, and also it's highly unlikely, as I said, that you would take off your gloves in the middle of breaking in and put them back on.
There was no evidence to that effect.
No, but there's no...
You're saying that's common sense.
There's no prints anywhere else. There's no prints on the window. There's no print that you lift up. And there's no prints on the sill. And there's nothing on the chair. And there's nothing. So, and I'm not saying you have to believe me that's what happened. I'm saying the defendant was entitled to present that to a jury of 12. And he was entitled to have the same more probative than prejudicial standard applied to defense evidence as is applied to the evidence offered by the Commonwealth. Let me give you a compare and contrast, not to have like a cheap segue. But what's this with the ninja sword and the 9 available weapons? It was a blunt, sharp weapon. Which, so what do we got? A pliers, a wrench, pipe cleaners? I got 14 weapons there, including the defendant could have committed this with the samurai sword. Now, we got a state of affairs where the Commonwealth is permitted, because it's more probative than prejudicial, to bring in a Home Depot hammer and an imaginary Ninja Warrior tool that could not have fit through the window, and that doesn't prejudice or confuse, and the jury is expected to understand. But we're not allowed to put on Chartier, who the police took your tax dollars to travel to Georgia to interview, because it was so likely on the same evidence that the defendant couldn't even get to the jury, was likely enough to send 2 cops to Georgia to interview a guy and Mirandize him. So it's not nothing they had on Chartier. And the guy that lives next door, what about him? He's got the same... they have the same weapons that come in against this defendant, can't come in at all against all these other people who are just as likely to have bummed a cigarette from this guy. You know what we have here? We have the weekend of a burglar is really what we're looking at here. And the defendant, there's no reason in law for the defendant to have a higher burden to introduce evidence which by its nature is no more confusing than any other evidence in a criminal case. Alibi witnesses, prior bad acts, DNA evidence. I mean, a lot of evidence is confusing. And juries get limiting instructions. Juries are expected to sort things out. Juries are expected to understand that, what's related to this. And a defendant shouldn't have a bigger burden in putting on a case than the DA does. If anything, it's supposed to be the other way. And it's not supposed to be, and this is where Holmes makes it clear, which is why if you tell me no, we got to go up. I mean, Holmes makes it clear that the defendant's burden can't be judged by what the Commonwealth has. You can't say, well, they have DNA, therefore my guys are totally useless, because it can't be premised on the strength of the Commonwealth's proof. That question of probative has to be determined if independently the third-party culprits are even slightly suspicious, slightly more probative than prejudicial. And for instance, Chartier is the strongest case. What were they doing down there interviewing him if he was entirely irrelevant? He wasn't. And he didn't get less relevant because the Commonwealth's case got stronger. He remained as relevant as he was from beginning to end. And we don't judge the probative value of the third-party culprits by the strength of the Commonwealth's case, because to do so would be to make the same mistake South Carolina did when they prosecuted Holmes, saying just because their case is really good, your guys are out. That's the thing that violates due process and a right to present a defense, which is preserved here. Now, I see my time running. I want to talk just a little bit. I mean, we have addressed this question of the piling on of imaginary weapons. And that is a discretionary standard with the trial judge. But you do want to say, okay, what is the Commonwealth allowed to make a case with, and what is left for the defendant, which all evidence in his favor, suggesting it might be someone else's excluded. But I do want to look at that parade of clowns. And I want to direct the court's attention to Commonwealth versus Wayne Miranda, which you decided since I briefed this case, where the court said prosecutors shall no longer give money to witnesses in exchange for testifying, in exchange for the Commonwealth. And I want to point out, and I know this is probably like the slow dripping of water on stone, but when you give time to somebody, time is money. When you say to someone, otherwise you would have to do 15 years in jail for trafficking, but now you go free, you've given that person 15 years. And to give someone 15 years, it is the same as giving them cash. It's not different in terms of affecting the reliability of their statement. And I know the jury gets to see, and you would say, I'm sorry for gesturing, you would say, well, the jury can be expected to sort it out, and the jury gets an instruction, and they say that we know this guy got 15 years off a possible sentence and a deal. But it is worthwhile in this particular case, noticing strangely nobody came forward until, till deals are offered and until after the DNA, nothing before that. So strangely, these are, I want to say, manufactured, paid witnesses, the same as the witnesses are paid when they're paid cash. And this court has said prospectively, no more cash payments. And you might want to think in 33, in murder cases where the standard is different and you look at a different standard, what does it mean to have, nobody took a confession that didn't get a deal. So, you have
But Miranda actually did not say no cash payments. It said no cash payments contingent upon a conviction. Is there any evidence here that any of the deals were contingent upon a conviction?
No, Judge, you have the record before you. It's not contingent on a conviction, but on providing of it. Well, you have the record. Other than that, I think you have my case. Thank you.
Thank you, counsel.
Good morning. May it please the Court. My name is Elizabeth Dunphy Ferris. I'm the Deputy First Assistant District Attorney for the Northwestern District and will be representing the Commonwealth. The defendant raised 4 issues in his brief before this Court, and I would seek to address each of those issues. I do, however, have 2 typographical errors that I found in my brief and would like to alert the Court to those. First is in the table of authorities, which is found on the 4th, Roman numeral 4th page. In the case of Commonwealth versus Halbert, it should be 410 Mass, not obviously 4,110 Massachusetts. In addition, on page 16, on footnote 9, the second line, the transcript site should read volume 12, page 162 to 163, not transcript 8, 163, and I apologize for those errors. First, it's the Commonwealth's position that the trial judge correctly applied the evidentiary standard for third-party culprit evidence.
But what about Mr. Chartier?
Mr. Chartier, in relation to the proffer, which the defendant's proffer is found at volume 12, 162, 163, and 170, was an individual who, it came to police attention during this investigation, smoked Camel Wides, which was the type of cigarette that was left at the crime scene in this case. In addition, that he could have had access to weapons which were sharp force. As a factual backdrop,
We had a hatchet, didn't he?
he had a hatchet, yes,
Which the medical examiner testified could have been one of the weapons.
absolutely, yes. Well, the type of hatchet.
Yes.
There are different types of hatchets. In relation to the type of hatchet, it had a sharp force. It also had a dull side to it. But the medical examiner testified specifically it wasn't a smaller type hatchet. It was a certain type of hatchet, but I would suggest that the record doesn't suggest that the hatchet Mr. Chartier had could, and it doesn't suggest that it couldn't. It was merely described as a hatchet as an offer of proof from the defendant, and that is what this court is dealing with, is what was the defendant's offer of proof at the time of trial. As a factual backdrop, I would remind the court, for the purposes of the evaluation of this type of evidence, that this case remained unsolved for a period of close to 1 year. The date of death of Mrs. Martowski was when her body was found on October 10th of 2005. The match to the DNA sample, which was deposited upon the Camel cigarette, was sometime in September of 2006. In addition, there was additional evidence that the defendant also was interviewed by police and made statements that his DNA would be nowhere near Mrs. Martowski's home, that he was not familiar with her home, but had done work at a neighbor's home, the Gurkha's home, which is the subject of his convictions that he does not challenge before this court of unarmed burglary and larceny under $250. But with that factual backdrop, that this case went unsolved for 1 year, but that very early on, the testimony in the record shows that the police were able to obtain a DNA profile, partial profile, from the Camel cigarette that was left at the crime scene. And that was put into databases. It wasn't matched until the DNA sample of the defendant. But in this record, you will also see that there were DNA samples taken from tens up to hundreds of people in this case. In fact, the exhibit which the prosecutor uses in this case put forth all of the DNA profiles that were obtained in this case in order to solidify the match in this case. And I just take a moment to correct the record. There is nothing in the record to say this was quote-unquote handler DNA. In fact, and that has a significant term in forensic science, and it was not proffered as handler DNA. This was biological material tested at the state laboratory, which yielded a partial DNA profile.
Well, can you explain what that means in English?
Yes, Your Honor.
What do you mean, handler? What handler means?
Yes.
Handler DNA in forensic science, which has not been put forth in this record because it was not proffered as handler DNA, is DNA usually found upon a murder weapon or a item in which the findings suggest that the biological materials left upon the DNA, left upon the sample, the evidence being tested, was from epithelial cells. Scientists can determine that based on strength and other types of findings in relation to their analysis when it goes through the finding of analysis for the 13 CODIS sites, which are the alleles that a DNA analyst looks at. In this case, the DNA analyst testified that there are several types of biological materials that can leave DNA profiles. And in this case, she testified it could be saliva, it could be blood, it could be epithelial cells. However, it was not proffered as being epithelial cells over any other type of biological material. This was a cigarette, and it was proffered for being that the DNA profile of the defendant was there in conjunction with evidence in a police interview that he claimed his DNA profile would be nowhere near that address.
How did that come up? Did the police, I just, maybe it's there and
He
I
was
just haven't read it. Did the police say, is your DNA going to be found on this site, or did he volunteer it, or how did that?
Well, there was an interview because he was a suspect in additional robberies for which the Commonwealth attempted to join but was denied an ability to join, particularly the Simolinus break. Based upon the Simolinus break, his DNA was, he gave the DNA to, consented to give his DNA sample to police investigators.
So just let me back up. Did you say that this DNA, that the source of this DNA was not epithelial cells?
It was not testified to being epithelial cells.
That was one of several.
It was one of several types of biological materials.
But was there any specificity as to whether it was DNA that came from saliva, from, for instance, putting a cigarette in one's mouth?
No, this was a partial profile, so not all sites yielded results that could be tested, and so therefore that type of analysis where they use strength versus less strength to determine the possible source was not done in this case. I presented to the court only for the proposition that the Commonwealth's case did not rest that this was handler. It is entirely consistent that the intruder into Mrs. Martowski's home wore gloves because there is no fingerprints upon the point of entry, and there is a smudge consistent with an individual having worn gloves upon the point of entry, and the significance of the cigarette being left to prop up the window. That cigarette yielded one DNA profile. So in this case, it yielded inculpatory evidence for the police to then look to determine whether this was the individual who broke into the house, and then to determine whether the individual who broke into the house was as well the individual who caused the fire and who killed Mrs. Martowski.
Just as a point of information,
Yes.
If it were handler DNA, if it were specified as handler DNA, does that mean that it would have been an epithelial cell, for instance, from the fingers, as opposed to saliva or blood?
Commonly in forensic science, that would be when they use that term. That is, it was handled as opposed to...
Put in the mouth or had blood on it.
Correct.
Okay.
But it does not follow that if these were epithelial cells, as my sister suggests to this court, that it means that the defendant only handled, that is, only touched this cigarette and then it had no other significance. Because in this case, although processed against literally 100 different DNA samples, the defendant was the only individual who matched. So it rendered inculpatory evidence for investigators in this case, but more importantly, and particularly as to the third-party culprits, it rendered exculpatory evidence against each of them, each of the third-party culprits that the defendant cites as being individuals who this cigarette, as to two of them. As to the other two, the cigarette doesn't really come into play. So
Where on the cigarette did the DNA sample come from?
the testimony was that the cigarette was swabbed, and then the swabs were tested.
But
So-
it didn't indicate whether it was from the part of the cigarette
I
that...
think it was the filter, wasn't
Yes.
It was the filter?
Yes, the
Okay.
filter, the
And was the
lower part of
Was the cigarette unsmoked, or was it?
It was unsmoked.
It was unsmoked. It was a full unsmoked cigarette.
Yes, but certainly an individual who is trying to prop up a screen can utilize his mouth to open up a pack of cigarettes and take a cigarette out, or DNA, certainly individuals who place cigarettes behind their ear. It is a possibility that DNA can be deposited based upon cells that appear when that individual either sweats or just cells floss off from that individual's skin. The essence here is the identification of the defendant's DNA profile in statistical significance in relation to this case, and coupled with the exclusion of every other individual that the defendant claims were probable third-party culprits to admit to the jury.
Sorry, finish.
As to two of them, the cigarette comes into play. That would be Richard Chartier, who smoked, the proffer would be smoked, and in fact smoked this brand of cigarette. And therefore, his exclusion from the cigarette in the home is compelling evidence that exculpates him, because the only relevance of the cigarette is the DNA profile, which identifies an individual whose biological material had come in contact with that cigarette. In and of itself, the Camel cigarette is a finding, but it yields no evidentiary significance
So
for
what you-
or against.
So what you come out with is the cigarette drops out of the picture, at least as Mr. Chartier is concerned.
Correct.
And so then you say, well, if you have somebody who's where he was and has access to a small hatchet, then but that's all you have, right?
Correct, and yes.
I mean, the
it's
cigarette becomes irrelevant.
correct.
So where was he?
And there was no hatchet found to be able to test to determine if there was any biological fluid from Miss Martowski left on any weapon. It was merely testimony that he may have possession of weapons.
Well, so that while Chartier was a possible link, it was really speculative.
It was speculative. It was early on in the investigation when the police were canvassing. This was a brutal crime in a small town where a elderly woman's home was invaded, and the police went to the factory next door and asked for the DNA samples of all the individuals who worked there. They were asking for DNA from anyone who would give them a DNA sample, because the essence of the evidence that the police had during this year investigation was that the point of entry had a DNA profile on it. It may have been in investigation, it was not so in this case, but it may have been an investigation that DNA profile had an innocent attachment to the house. That's not what happened once the police found who the DNA profile belonged to. They then found that this was an individual who had committed several burglaries in the area at about the time of this murder and was continuing to commit burglaries in this area. And that is how he came to the attention first to the police. He was caught on a burglary that it was the Commonwealth's position, when it provided a motion to join these cases, that was of the same mode and operation. The trial judge ruled that he felt it was too prejudicial to try those cases together, but that is how the evidence came into play.
All of them, but one of them got tried.
One of them got tried. The other break that occurred in the month of October in September, I'm sorry, the September
End of
break, and
September,
he was found innocent of the attempted break to the next door neighbor's home, of the same home, the Gurkha home, on October 10th. So the scenario of what went to trial was on September 19th, 2005, the defendant committed an unarmed burglary in Miss Martowski's neighbor's home, the Gurkhas, Frank Gurkha's home. In that burglary, similar to Mrs. Martowski's burglary, the defendant rifled through drawers. He overturned the contents of the drawers throughout the residence. He also took momentums. In that case, specifically, a Apollo 13 decorative glass bottle. And they were all smaller mementos. That is, he did not take televisions, stereos. He sought to take money and other types of collectibles, which were the types of items that were stolen from Mrs. Martowski's house as well. And it was in the manner that is going through the drawers, taking the drawers out, dumping the contents upon the floor or the bed, whatever area it is of the home that he was in at that time. Those were joined, and I would suggest that is in addition evidence in relation to the defendant being the perpetrator of Miss Martowski's
Now,
murder
there was
as well.
some testimony from someone that he gave them one of those bottles.
Yes, Mr. Brown, who is one of the individuals who my sister claims there was an offer of proof at trial for third-party culprit in Martowski's murder. But when you look at the record, which would be found at volume 11, page 90, Mr. Brown is not offered by trial counsel for the defendant on the theory that he was the perpetrator of Miss Martowski's killing and burglary and arson, but more to the point, he was the Gurkha's perpetrator. Now, there may have been a logical inference, which the Commonwealth was dealing with, that the same intruder did both crimes, but it wasn't proffered to the judge the way my sister suggests. So but he was, Mr. Brown, Mr. Ruell's friend, and he was an individual who, in July of 2006, in celebrating his birthday, the testimony was Mr. Ruell gave Mr. Brown that Apollo 13 decorative commemorative bottle for his birthday present.
I'm sorry to go back to Mr. Chartier, but
Yes.
Ms. Martowski was killed on October 10th, correct?
Yes.
And was that found, it was found, in terms of the police arriving and the time of death, was that fairly close, or?
Yes.
Okay. So was Mr. Chartier found somewhere in the vicinity right at that time?
No.
What's his connection?
The police, he has no our
Was he
position at
physically,
trial.
no, I'm not saying legally, but just physically, how did he come to the police attention at all?
This case remained unsolved, but it had some significant markers for investigators. One being the type of burglary. Some burglars go into homes and take different types of materials. So the type of material that was stolen was being looked at. And so any neighboring communities, police forces.
So
were
what was
asked,
what was the spatial connection between Chartier and this victim's home?
They live in generally the town area.
Like miles, within miles?
I don't know the actual distance. I can tell you that police didn't just look at they specifically looked at individuals in Ware that would have been arrested for breaking and enterings during that time period. They also went back through Corey's to look for individuals that had previously been convicted of any type of burglary, whether or not it included deaths, because of course in this case it did not include.
But was Chartier's connection, what was to the best you can tell us, was he from an adjoining town? Was he seen?
Yes,
And that's the best.
He had a girlfriend in the area.
He wasn't found, when the police arrived on October 10th, he wasn't
No.
anywhere near there.
Not to my knowledge, Your Honor. More importantly, it was not offered to the trial judge as a reason. And I don't want to, I know Mr. Kowalski, who's another individual, he actually had a girlfriend who lived in the neighborhood, and he became a suspect. He became an individual that the defendant claims is a third-party suspect because when just talked to by police, because he was an individual within the area, he said to someone else, they think I'm a suspect merely because the police talked to him. That's the offer of proof there. As to Mr. Chartier, he was I would say the record reveals he was a local individual. He smoked Camel Wides. He was, I believe, known, I'm sorry, Your Honor, I think Mr. Chartier was known to have been at Mary Lane Hospital, which is next door, the driveway that goes to Ms. Martowski's home. Mr. Chartier, I believe, had been at Mary Lane Hospital at some time period relative to the period of time of the killing. I'm sorry, I don't have the exact. I can give the court a letter of reference, but more importantly, it wasn't a offer of proof by the defendant in this case. There are several other issues. I have fully briefed them for the court.
Is that a mental hospital?
No, it's a emergency acute care hospital. During the investigation in this course, we used the grand jury to determine all individuals who received emergency care that evening or would have been documented somehow, employees, everyone, to determine whether or not any of those individuals would be willing to give DNA samples, which many did, and it was just a matter of an investigative tool while this case remained unsolved. The big item of an important item here obviously was the DNA profile at the point of entry in this home, but it wasn't the only evidence in this case, and the defendant...
I'm going to have to stop you.
Yes, Your
Your
Honor.
2 minutes over. Thank you.
Thank you.
All right.